All right, and we're back, and this is Corpus Juris Secundum 9, subsection 272, banks and banking. And my reason why I do all this just contacted me this evening and has filled my heart with so much joy. She's the reason I'm alive. She's the reason that I'm still here, and for no other purpose than to ensure that she has the acquired knowledge she will need to succeed in her life, is why I do these videos. Because nothing in the banking system has changed in over 10,000 years. In fact, it's even older than that. It goes all the way back to when Barney Rebel figured out he could get Fred Flintstone to mow his grass while he set his happy ass on the couch. All right. It's biblical, ladies and gentlemen. It goes all the way back to Jesus Christ or Yahweh opening up a can of whoop ass on the money changers. Okay. For their false and misleading and deceptive trade practices, their failure to disclose, changing the currency, charging interest on something known as, or converting it into something known as debts. All right. Sins and debts are synonymous. They're the same thing. And one of the spiritually uplifting things, although as gruesome as it may sound, was when I read about the persecution, and I started to realize that all value always returns to its source. So you hear people say washed in the blood of Christ. Well, the blood is the life source energy of the body. All right. In your body, you have anatomic gold, minerals, oils, water, electricity. Everything in your body is of value. Okay. And that body, because you were placed in that body by divine intervention, that body belongs to you. It's yours to use, given to you by the grantor. I think the odds of being actually born are like 1 in 400 billion or some astronomical number. I mean, if your mom would have went home with a rock star instead of going home with your pops, you would have never existed. If she'd have slipped, tripped, bumped her ankle, and couldn't make it through the rest of the evening, she'd have never met your dad. I mean, when you start to look at the probabilities of you being on this earth, it's incredible. And I guess what I'm trying to get at is don't waste a second of it. It's a brilliant gift. Take hold of it. Enjoy it. Understand that it's going to come with hard knocks, tough lessons, but you were built to endure it. So through our trials and tribulations, we ascend of the mind, mentally, physically, spiritually, and otherwise, because he built us to be able to endure such trying times. The blood running back into the earth is the symbolism that all value returns back to its source. From the dirt you come, and so the dirt you shall return. That's your body. But your physical spirit, the essence of your life, is breathed into your nostrils as a gift from the grantor. And we have to consciously make a choice to accept that gift, because it is a gift. It's not to say that it won't come with heartache and trying times and adversity, but through trials and tribulations and adversity comes perseverance, which builds character, which leads to a fulfilling life. A lot of people say, oh, well, it's I see people that they have a better life than me. I'm going to tell you right now, I've met a lot of very wealthy people in my life. I was fortunate enough to be building really nice, extravagant custom homes. I've traveled around the United States all my life, and I have met extraordinarily wealthy people that are the most miserable people on the earth. All right. I've met people that have never had to struggle, and their life, they're just lost. They're looking for direction. They have everything they could ever want, and yet they're so empty. And I've also seen people that are absolute destitute, and they are the happiest people that you will ever meet, because through their trials and tribulations, they found who they were. Their life has purpose and meaning. They see the finer things in life. They also comprehend that the struggles that they went through and the scars that are left on them, whether physically, mentally, or otherwise, have caused them to be able to enjoy life more because of their trials and tribulations. So I'm always thankful for the trials and tribulations that the Heavenly Father puts me in, because I know that He built me to endure the storm. He built me to ensure that I was strong enough to endure what He had planned for me. Free will. It's a beautiful thing. You have free will. You can do what you want, when you want. He doesn't say that it doesn't come without repercussions. It doesn't come without consequences. But He put those rods of God in your way to lead you back home when you wander astray. Because innately, as man, the only thing we learn from are painful experiences. So without further ado, this video is very special to me because I had a long, pleasant conversation with my offspring. I love that little girl with all my heart. And we were talking about future estate planning. We were talking about her current events that she's familiar with in the world, which struck me as odd how fluid she was with the things going around her. She's like dear old dad, keeps her shit wired tight and her head on a swivel. She's always paying attention, and it's a beautiful thing. And we started talking about planning for doing a couple hours a week, learning banking, the financial industry, future planning estate, trust law. And like I told her, someday you'll go to a college and you'll do a tour. And the college, no doubt, will be grandioso. It will be beautiful. There will be people your age there. It will be exhilarating to be there. The beautiful corridors and the aesthetically pleasing construction and architecture will just undoubtedly overwhelm your senses. But I said, my little precious angel, it's not the building, it's not the school that's going to teach you anything. What will teach you is when you walk outside into the parking lot and walk around that parking lot. And not that we're materialistic in any way, shape, or form, but if you want to learn about finances, if you want to learn about how to become financially independent, how to handle your affairs and come up out of her, how to utilize the trust for your benefit as it was set up, you're going to have to do it on your own, because they're not going to show you how to do it. And I told her, when that day comes, I want you to remember, I want you to walk out into the parking lot, and I want you to look for the Maserati, the Lamborghini, the Ferrari, the Rolls Royce, the Bentleys, $300,000, $400,000, $500,000 cars, and tell me how many of them you see in the college parking lot where the teachers park. And if you don't see any of those, I want you to always keep this in your mind, that people go to college because they aspire to do great things in their life. They aspire to find a path or a career that leads them to some type of financial stability. But yet, if the very people that are going to teach you about finances are in debt, the nicest automobile they have in the parking lot is a Subaru Forester, chances are the school that you're going to pay $250,000 for, interest up front first, of course, because you never pay down the principal till the interest has been taken care of. More than likely, those people aren't the ones to teach you about banking, aren't the ones to teach you about finance. One of my mentors told me a long time ago, he goes, Derek, I see some of the people you hang out with. And I said, well, before you go down that path and you start bashing on these people, I said, I just want you to know they got good hearts and they mean well. And he says, oh, that's all fine and dandy. He said, but I seen one of them the other day. We all showed up at a restaurant. He said, I seen one of them the other day. Go, what do these people know? And you could do better without them. And he says, I'm going to give you one good piece of advice. Don't take advice from broke people about finances. And I was like, that's a pretty damn good fucking point there. He says, I'm trying to help you, but the company you keeps trying to pull you away from learning how to create generational wealth. I said, I understand. And he said, so I'm here, self-made at the age of 21 years old. He was a millionaire. Bought his mom's first house for her when he turned 21 years old. At the time I had met him, he was multi-millionaire 10 times over. It's really not about the financial wherewithal. What he's pointing out is, although it doesn't make you happy, it sure doesn't fucking hurt to be able to take care of people that are worth your time. Be a mentor to people that value and respect you and appreciate your time. And he said, these people that keep trying to give you financial advice saying coming to these meetings is never going to do you any good. He says, I'm here to tell you right now, you're at least taking the initiative to open your mind and look at the plausible possibility of what could be, where they have closed their minds and decided they're going to go play video games in their mom's basement and try and drag you along with them, which I don't play video games anyway. But the moral of the story is, if you want to gain acquired knowledge, you have to hang around the people that are applying themselves. You have to hang around the people who are willing to put their neck out there on the line and do things that 90% of the populace never will do. So with that said, for you youngsters out there that think college is the way to go to create generational wealth or financial independence, I want to stress to you, when you get to that college and you start looking around at the school and all the pretty girls or all the good-looking hunks and handsome men out there, before you leave, make sure to take a walk around the parking lot and find out if where you're going to school at is really going to teach you about financial independence. Because if you're not seeing the finest things in life sitting in that parking lot, chances are none of them know how to do it. Because if they did, your professors wouldn't be professors at college. They'd be in Bali on a damn fucking private chartered boat or fishing or doing something other than hanging out at a college. The first lesson you will learn at college, and I know this with firsthand knowledge, although I dropped out of school at 13, I did manage to get myself into college without a high school diploma or a GED. And the first thing I learned was how to acquire debt really fucking fast. It was the first thing I did. Within 5 minutes, I was immersed in the world of debt. Now, since then, it's all been taken care of, but that's not the point. The first thing college will ever teach you is how to amass a shit ton of debt really quick, all right? And debt that you won't necessarily be able to get out of until you acquire this knowledge. So, without further ado, duty as respects third person. Banks are under no legal duty to warn investing public as to financial conditions of their depositors. That's great in a number of ways. One, if you're doing business with Wells Fargo and you decide that you really don't like the way they do business, so you're going to venture off and do business with U.S. Bank, Wells Fargo and U.S. Bank can't communicate about the business that you did with Wells Fargo. All right. So, and if that happens, it's a breach of trust and it's a violation of the law. It's an invasion of your privacy. So, keep that in mind. Duty as respects third person banks are under no legal duty to warn investing public as to the financial conditions of their depositors. They are never, ever, ever to be divulging or discussing with any other entity out there about your affairs with their organization. Ever. Okay? Let's move on here. All deposits made with bankers may be divided into two classes, namely, those in which the bank becomes bailee of the depositor, the title to the thing deposited remaining with the latter, and that other kind of deposit of money peculiar to banking business, in which the depositor, for his own convenience, parts with the title to his money and loans it to the banker, and the latter, in consideration of the loan of the money and the right to use it for his own profit, agrees to refund the same amount or any part thereof on demand. All deposits made with bankers may be divided into two classes, namely, those in which the bank becomes bailee of the depositor, the title to the thing deposited, notes, drafts, bills of exchange, bankers' acceptances, trade acceptances, contracts, remaining with the latter, and that other kind of that other kind of deposit of money peculiar. That's your notes, drafts, bills of acceptances, trade acceptances, vouchers, coupons, dividends, checks, okay? Dividends to banking business in which the depositor, for his own convenience, parts with the title to his money. Okay, notes, drafts, bills of exchange, bankers' acceptances, trade acceptances are the new money under the new law, ladies and gentlemen, and they are extended to the banks. And if you don't believe me, go look at Title 12, 1431. All right, the only power the bank has is to borrow. Okay, and in the 73rd Congress, it is very, very clear where the new money in the economy comes from under the new definition of money under the new law. And that's notes, drafts, bills of exchange, bankers' acceptances, trade acceptances, period. That is then lent to the bank, and the bank takes it to either a federal discount window or a Federal Reserve agent and takes it to the Treasury, and then has the comptroller of the currency reviews it and authorizes the Treasury to go ahead and print per the value on the face of the instrument that amount of Federal Reserve notes into circulation, all right, and loans it to the banker, and the latter, in consideration of the loan of the money and the right to use it for his own profit, agrees to refund the same amount or any part thereof on demand. A general deposit is one where the bank is given custody of money. Again, for this illustration, money comes in a form called medium of exchange, okay? Notes, drafts, bills of exchange, bankers' acceptances, trade acceptances, vouchers, coupons, okay? Contracts. You want to know how I know that you can deposit a contract into a bank? Because when I was a contractor, I had a contract signed for my performance and their promise to pay, and I needed the funds up front to go get the materials, and I happened to go talk to a banker who said, well, let me review the contract. Okay. Now, at this point in my life, I knew nothing about banking. Nothing. I mean, I understood that you could deposit and withdraw and make transactions and swipe a plastic card. And he reviewed it and he said, hey, I'll tell you what, cut us in on 10% of this, sign it over to us, and we'll go ahead and advance you the funds. And I said, really? And he said, yeah, this contract's good. You go ahead and sign it over to us. We'll hold it. And then upon you finishing the job and compensating us back for what we extend to you, then we'll give you back the contract. Well, at the time, I never understood the importance of having the contract back. I was like, why would I need that back? You know, at the time, I'm giving the estimate, then I go through the billing process, and then the check is issued, and I always just walked away. But here was a quintessential piece that I was missing. You see, upon completion, when everybody has performed their obligations, I still have one obligation left, and that is to return the contract to the interested party, which would be the one who signed the contract to give me the opportunity to work for them. And that was the very contract that the banker was holding. Now, none of that made sense to me until a couple of years ago when I realized what had actually transpired. They took the note, they held the note, they extended to me, and then they turned around and gave the note back to me after I had fully made good on the agreement that we had. And it just never dawned on me what actually had transpired. Now, the banker was cool. He was helping me out. I was in a pinch. I was in a jam. I didn't have any credit, but what I did have was a contract from a reputable family who had good credit and a name within the community. And they're like, yeah, we'll do that. No problem. So a general deposit is one where the bank is given custody of money, notes, drafts, bills of exchange, bankers' acceptances, trade acceptances, promissory notes, all right, with the intention, expressed or implied, that the bank is not to be required to return the identical money, but only its equivalent. Okay, well, if you're giving a note, a draft, a bill of exchange, banker's acceptance, trade acceptance, ladies and gentlemen, what do you think a Federal Reserve note is? It's the equivalent. It's the same thing. Okay, it's a promise to do something sometime in the future. All right. General deposits. In a commercial bank comprise all money. General deposit in a commercial bank comprise all monies that are simply deposited therewith on account of the depositor without being complicated by any other transaction than that of the depositing and withdrawing of the monies by the customer from time to time. General deposit. There can be no doubt that as between its depositor and a bank, the relationship of debtor and creditor exist. The depositor is the creditor of the bank in the amount he has on deposit, and the bank is a debtor to such creditor for a like amount. Meaning, if you're depositing notes, drafts, bills of exchange, bankers' acceptances, trade acceptances, contracts, that's an asset on the balance sheet. And the bank has to match that asset with a liability. All right? The bank proclaims to be lending the depositor's funds or credits back to the borrower, the alleged borrower. Well, here's the problem. The bank cannot lend other depositors deposits, okay? So in one aspect, they're not lying to you, but they are being a little bit deceiving. And here's how. They never had the credits on the account until you gave them the application, the promissory note, and if you follow the 73rd Congress, you're also to give them the warehouse receipt, which is the birth certificate. All right. Now, those credits came from the depositor, no doubt, but that depositor is you. You're the creditor extending them a loan. All right. Every general deposit of money in a bank, whether in checking or savings accounts, on certificate of deposit, payable on demand or time, creates the relation of debtor-creditor. They're the debtor, you're the creditor. All right. Fix this so you guys can see that a little better. The bank is not a custodian of a deposit, but a debtor to the depositor in the amount thereof. The original and every subsequent general deposit is in strict legal effect a loan by the customer to the bank. Account of husband and wife deposit of sum in bank to joint account of husband and wife created relation debtor and creditor between bank and husband and wife. Public or private funds. When funds, public or private, are deposited in a bank upon a general deposit, the relationship of debtor and creditor is created. In effect, the funds are loaned to the bank. Despite application to specific purpose, where a bank receives money on deposit, which is to be mingled with its other assets and become a part thereof, the relation created by the deposit is that of creditor and debtor, although the amount represented by the deposit is to be used and applied to a specific purpose. Wait, sorry. I don't know if you guys can see that or not. Let's see if we can fix it for you guys. There we go. A little bit better. Sorry about that. There. Deposit with private banker. 1. Where the legislator has not determined what the obligations of private banker to his depositor shall be, the relation is determined by the common law. It is firmly settled as debtor and creditor. 2. Arrangement whereby private banker gave depositor credit, passbooks, and required that passbooks he presented for withdrawals and that 2 weeks' notice be given for withdrawals exceeding $100 did not change debtor and creditor relation implied at common law. So that was the agreement between the bank and the creditor, and they were wanting 2 weeks' notice, and it was agreed upon, and that created a contract, and it is still a creditor-debtor relationship. All right. You can contract with your bankers, ladies and gentlemen, and you need to start opening the realm of possibilities of scheduling a call, calling down to the bank and saying, hey, I need to know who the Federal Reserve agent is at the bank, or who the bank manager is. I'm doing some life estate planning here, and I'm looking to negotiate some peculiar banking instruments and documents, and I would like to know a time that would be mutually beneficial for all parties involved to sit down and go over these deposits that I look forward to be making in your establishment very soon. All right. and open the door that way. Remember, a gentleman and a lady always give announcement of their arrival. We need to schedule appointments and sit down and have good conversations. All right. 3, private banker holds title to capital and assets, and depositors are not owners of deposits, but creditors with preference over general creditors as respects certain assets. In case of deposit of negotiable paper, the relation between bank and depositor is converted from that of agent and principal to that of debtor and creditor immediately on payment of deposited paper. All right, we're making a deposit. We're not giving them the paper. We're not giving them the over-counter security. Remember, in order to create a security, you just need the application, retail installment agreement, or sales agreement with the promissory note or bill of exchange. And that is the security. All right. And so in this relationship, comprehending what it takes to actually create a security is very beneficial, because in the 73rd Congress, in order to create a security, it's the application for credit, note, draft, bill of exchange, banker's acceptance, trade acceptances, or contracts with a receipt. Okay? And those papers bundled together create what is known as a security. So why are you giving them a security interest in your private household consumer goods when it is not required by law? Now, if the bankers turn around and tell you that you have to, or they're not going to do business with you, that's a violation of Title 15, subsection 1, subpart 1, interference with trade and commerce, which comes at a $100 million fine if they're a corporation, agent and agency doing so, or if it's they're acting in their individual personal capacity, all right, then it's $1 million fine, okay? Because now they're meddling with the United States Treasury, getting their tax revenue while you're trying to bring down the national debt, all right? And so they take it very seriously, and you have to report it. Not only does the United States Treasury take it seriously, the Federal Reserve Board of Governors also takes it seriously. The FTC takes it seriously, okay? So know that you have options if you choose to become learned and you make an observation, create a record, and then report it. You will see results, okay? Reservation of rights to chargeback if uncollected. A debtor and creditor relation, rather than principal and agent, held to exist on deposit of a draft where bank credited depositor's account with amount of draft drawn by later payable to bank and allowed him to check against it, but reserved right to charge back amount of draft if it was not collected. In case of general deposit, there is a depositor, not a bailor, a debtor, not a bailee. So in other words, in the case of a general deposit, it's a debtor-creditor relationship. It's not a bailor-bailee relationship. All right? And in the case of a general deposit, there's a depositor, not a bailor, a debtor, not a bailee, a creditor, not an owner. All right? Relation as not confidential. It does not suffice as a basis for a claim of a confidential relation that the relation of banker and depositor exist. It is the usual custom with many depositors in business transactions to ask the banker for his opinion of the transaction, but to say that that under such circumstances a confidential relation is created would be going too far. Now, I haven't read this case, but judging by that conclusion, I really think the depositor probably said that he had a special trust relation with his banker and he took the advice of his banker and something didn't go to plan. Now, I'm just speculating here, but I will go read this case. That's the Klatt versus First State Bank of Kalmar, 220 N period W period 31S 320 206 Iowa 252. So, claim that bank was trustee ex maleficio. Deposit was not impressed with trust on ground that bank became trustee ex maleficio because of its refusal to pay at expiration of 90-day period, since relationship remained that of debtor and creditor. Unless there are special arrangements, contracts agreed upon between the parties at the time the deposit is made that the money is a special deposit, the relationship between the depositor and the bank is that of debtor and creditor, and not trustee and beneficiary. Absence of fraud, we know of no exceptions to this rule. Deposits of money or equivalent. Generally, when a person deposits money, notes, drafts, bills of exchange, bankers' acceptances, trade acceptances, coupons, vouchers, money orders, okay, or its equivalent in a bank, such as defendant in this case, the relation of debtor and creditor is set up. Title to the funds so deposited immediately vests in the bank, making the bank the debtor, and whatever sum it pays on a check of a creditor's depositor is paid from funds of the bank, and thereupon, if properly paid, the bank has the right to charge the depositor with the amount of such payment. Deposit of bankruptcy funds in authorized depository generally vests ownership of funds in bank and creates a mere indebtedness on the part of bank to trustee making deposit. Deposit as asset. Deposits are not the property of the depositor, but of the bank receiving them. The relation of a bank and its depositors being that depositor or on his order on his order or demand, and in making payments. Oh, damn it, I butchered that. Sorry, guys. Deposit as assets. Deposits are not the property of the depositor, but of the bank receiving them. The relation of the bank and its depositors being that of debtor and creditor, so that deposits and investments are equally assets of the bank. Use in general business. A general bank deposit creates a debtor and creditor relationship, authorizing the bank to mix the deposits with its funds and use it in its business for investment purposes. Payment of interest on deposit by bank is strong, although not conclusive, indication that title to funds deposited has passed to bank and that relation between bank and depositor is that of debtor and creditor. As not subject to conversion. On receipt of deposit, it becomes property of bank, and bank becomes depositor's debtor, and depositors' allegation that bank diverted and converted deposit to own use did not state cause of action, since bank could not divert and convert its own property. So they put it in on a special deposit or a general deposit. So the bank owns it at that point. It's a creditor-debtor relationship at that point. Money deposited with private banker became banker's property, so that he could mingle deposits with his own monies, there being no contrary agreement, no other contract. The foundation wasn't set. The instructions of negotiating the note weren't put in place. The restricted endorsement or qualified endorsement was not there. Okay. And so it becomes the property of the bank. You didn't negotiate how much you needed to be compensated in lawful money for your extension of credit and your promissory note, which are, in fact, money under the new law. All right. So it's as though you gifted it to them. All right. When this got converted in with a computer program, it changed the words around a little bit. I'll figure it out in a second. When one deposits money in a on general deposit, the bank thereby becomes the debtor of the depositor for the amount of the money so deposited, and undertakes impliedly, so it's an implied contract. Implied contract. When one deposits money in on general deposit in a bank on general deposit, the bank thereby becomes the debtor of the depositor for the amount of the money so deposited, and undertakes impliedly to pay the money either to the depositor himself or to some person to whom he directs it to be paid, withholding funds. There is no rule of law that requires a bank or anyone else to withhold funds owing to another person on the ground that they have knowledge of the fact that someone else has an unsatisfied judgment against such other person. Receipt for a deposit of money in a bank imports an obligation to pay on a reasonable demand and is a written agreement contract enforceable at law. See why it's so important to get your receipts of your deposits that you're making, because without them, you don't have chain of title, you don't have chain of custody, you don't have any proof or evidence of the deposit, meaning that if you don't have any proof of that deposit, then you have no proof of a contractual agreement that is enforceable at law. So, buying a $350,000 house, you fill out a credit application, okay? You fill out a promissory note, you fill out a retail installment agreement or a mortgage paperwork. You need a bill of lading for all of it. Every document, every page should be accounted for. Every signature that you make should be accounted for. All the pages of documents should be accounted for, and that should be on a bill of lading, which is your receipt. And the trustee operating on behalf of the bank should be more than happy to sign that for you. So you now have physical evidence, proof of chain of title and custody of the documents that you created that have your life source value energy invested into them, all right? Because you are the creditor, all right? You're what makes the whole world go round. It isn't big bottom girls, contrary to everybody else's belief. It's you, all right? So receipt for a deposit of money, all right? And we already explained what money is. Promissory notes, drafts, bills of exchange, bankers' acceptances, trade acceptances, contracts, the credit application. In a bank imports an obligation to pay on a reasonable demand and is a written agreement enforceable at law. Necessity of demand. Although bank, in receiving deposit, impliedly agreed to repay same on demand, demand for repayment was an integral and essential part of contract. A general deposit consists of money which is mingled with the money of other depositors in a general fund chargeable with the payment of general deposits, possesses no trust quality, and loses its special identity in its general commingling with the funds of the bank. A special deposit is a deposit for safekeeping. It contemplates the return of the identical money deposited. The title of the money constituting a special deposit does not pass to the bank. The title to the money constituting a general deposit does pass to the bank. A bank deposit is special where the bank becomes bailee and title to deposit remains in the depositor. It is general if title passes to the bank and the bank has the right to use the deposit in its business, being bound only to return an equal amount or any part thereof, usually on demand. State bank, in the exercise of the usual and incidental powers belonging to the banking business, may receive special deposit. Return of identical bonds, where plaintiff deposited with defendant bank liberty bonds for safekeeping, the bonds constituted a special deposit not to be paid or accounted for by the bank in money, but by the identical deposit. When the identical money or other thing deposited is to be restored or is given to the bank for some specified and particular purpose, as to pay a certain note or other indebtedness, or is received by the bank as a collecting agent, such collection to be remitted, such deposits are special or specific. Methods of creating special deposit enumerated. To make special deposit, particular money or thing must be understood to be returned, or that money deposited by agreement be used for a specifically designated purpose, or that deposit must have been wrongful or illegal. Bank understanding and handling of deposits. Manner in which bank handled deposit or understanding of its officers and employees that it would be special deposit would not make it such without depositors' consent. They need your consent to make it a special deposit. You have to enter into that agreement. That agreement needs to be in writing if you're seeking to enforce it, because so often if you create that agreement orally, you won't have any evidence if two or more agents and agency state the contrary. All right. Bailment. A special deposit partakes of the nature of a bailment where the identical funds are to be kept intact and returned upon demand. Not always bailment. A special deposit is sometimes said to be equivalent to a bailment. It is not always of that order. Deposit of bonds for security or safekeeping. Where bank takes bonds of a customer as security or for safekeeping, relationship established is that of bailor and bailee, and not that of debtor and creditor, which would arise on a sale and purchase of the bonds. 2. When a bank receives bonds or other property of a customer for safekeeping, it becomes a bailee and liable as such. Trustee relationship shown. Bank with which stated gold and currency were deposited in trust by person not declaring themselves claimant thereof in contemporaneous trust instruments, which showed that money was deposited as another's property without directing disposition thereof, held not mere bailee but trustee having burden of making proper disposition of property. We'll go over that one more time. Make sure we drive that point home. Trustee relationship shown. Bank with which stated gold and currency were deposited in trust by person not declaring themselves claimants thereof in contemporaneous trust instruments, which showed that money was deposited as another's property without directing disposition thereof, held not mere bailee but trustee having burden of making proper disposition of property. Dual capacity. Bank which was chosen as escrow agent and which accepted and retained escrow agreement under which grantor delivered deed to bank and grantee delivered consideration, occupied dual capacity as agent insofar as manual duties were concerned and as paid trustee insofar as purchase money was concerned. Deposit of Liberty bonds. Where plaintiff deposit Liberty bonds in defendant bank to be kept safely by the latter and returned to plaintiff, the title to the bonds did not vest in the bank but remained in the plaintiff. Effect of mingling. Owner's title to funds held upon special deposit is not defeated by banks improperly mingling funds with general assets. Determining whether title passes. Sorry about that. Let's scoot this over a little bit. In determining whether title to funds passes to depository bank, agreement under which deposit is made and all conditions and circumstances of arrangement and legal character of transaction must be considered. Where note was placed in bank solely for safekeeping, the owner did not part with the legal or constructive possession thereof, conferred on the bank no power other than that of custodian, and retained the right of control and disposition of the note deposited as a bailment. Okay, fucker. It's a pain in the ass to move that back and forth. You got everything in there. Mere physical custody. Deposit with bank as mere bailee amount merely to physical custody for safekeeping, precluding bank's use of funds for own purposes. Modified contract as controlling. Deposit may be special, although mingled with other funds. Bona fide contract between parties being determinative of issue. Mutual intent to hold for special purposes. 1. To justify designation of account in bank as special deposit, not only its special purpose must be shown, but also intentions on part of both parties that it must be held and used exclusively for such purpose. To constitute special deposit, both bank and depositor must understand that fund is to be held for special purposes, and that bank shall not pay checks drawn against it for other purposes. If there is no malfides connected with the transaction, the, the character of the deposit, whether general or special, is to be determined from the contract between the depositor and the bank. Construction. All parts of written agreement between depositor and bank as to deposit will be construed together in determining whether deposit is special or general. No particular form of contract. Whether a deposit in a bank is general or special depends upon mutual understanding and intention of the parties with reference thereto. The law prescribes no particular form of contract. Explicit understanding. Where a deposit was made in a bank upon the express understanding that it was to be a special deposit for the purpose of organizing a bank and defraying expenses in connection therewith, it was a special deposit. Expressed or implied contract. Bank deposit is subject to any agreement which depositor and banker may make, and a special deposit may be created either by express agreement or of parties or by circumstances indicating that such was understanding of parties. Custom. The character of a deposit should be determined from all the evidence as to custom, course of dealing, understanding, and circumstances of the particular case under investigation. Drawing draft. Act of depositor in drawing draft against her deposit in bank was held to be incompatible with her claim that it was special deposit. Contracts attending making. Whether a deposit is general or special depends on the facts and circumstances attending its making. Separate listing. If, when plaintiff debtor deposited money in defendant bank, he directed defendant's cashier to list the deposit separately for plaintiff's benefit, a special deposit resulted. Specification of nature. The nature of the deposit, as well as its purpose, must be specified in order to constitute it as special deposit. Construing acts together. In determining the nature of a deposit of bonds with a bank, the various acts of the parties were to be construed together in ascertaining their intention. Bondholders' assessment. Bondholders' assessment deposited under agreement for purposes of retiring notes at maturity held to constitute general and not special deposit. Bondholders' assessment. Bondholders' assessments deposited under agreement for purposes of retiring notes at maturity held to constitute general and not special deposit. Cash bonds. You see these often in courts. Cash bonds deposited in bank, which the judge sitting on the bench is a bank and the judge is the banker, by officers accepting cash bonds for appearances in criminal cases become general deposits. Cash bonds deposited in bank by officers accepting cash bonds for appearances in criminal cases become general deposits, unless you want to stipulate to the fact that it's a special deposit and that you're entitled to it back. All right. Deposit by prospective bond purchaser. Where one already having a general checking account with a bank ordered some bonds to be purchased for his account by the bank and at about the same time deposited enough money to cover the probable cost of the bonds, and the money was deposited by regular deposit slip without anything to indicate a special deposit. The deposit was general and not special, and on insolvency of the bank, the depositor was not entitled to a preference as respects such money. Deposit to credit of municipal sinking fund. Deposits of money to credit of municipal sinking fund without any agreement to hold the same as a special account is a general deposit, which means, when you're going into the court and you're the one that's actually bonding the case, ladies and gentlemen, because they are insolvent. Okay, every corporation, anything with a DUNS number, an EIN, a TIN number, ladies and gentlemen, is insolvent. They bring no credit to the table, and that's why they're constantly extending you the offer, because the one that's making the offer is the debtor. You obviously have something they need, which makes you the creditor. Now it's a matter of negotiation, and we want those bonds to be a special deposit, wherein as soon as the accounting is all settled, we get the rights, titles, interest, dividends, derivatives, debentures, hediments, general tangibles, general intangibles, chattel security, trust residuals, trust residue, rents, profits, proceeds, futures, and annuities, all back. Once the accounting is settled, the account's brought to zero. All right? Balance to cover claims. Understanding between bank and depositor that depositor should keep deposits in bank sufficient to satisfy claims of local investors did not prevent deposit from being general deposit subject to check. Money paid for drafts. The purchase by one at a bank of drafts does not constitute the money paid for them a special deposit in favor of the purchaser. Time deposit. Against statement that deposit would be placed on earning basis is sufficient notice to principle that funds would be placed on time deposit and indicates that the deposit was general and not special in character. Bonds. Where Victory loan bonds were deposited with a bank for no other purpose than that of safekeeping, the deposit was a special one. 2. Where particular bonds deposited were to be returned, deposits were special deposits and bank was bailee. 3. Where a depositor left $2,700 of United States bonds with a bank for safekeeping, the bonds being placed in an envelope with other papers belonging to the depositor, who called at the bank and clipped the interest coupons, but the bank, without depositor's knowledge, sold the bonds, and later, without informing the depositor, executed an agreement with him specifying that the depositor loaned the bonds to the bank to be used by it, the bank to deliver bonds of the same description and issue except as to serial number. The depositor of the bonds, in the first instance, created the relation of bailor and bailee. Gold and currency. 1. Deposit of gold coin in banks, deposit vault without interest and returnable on depositor's demand is special deposit, under which title to coin remained in depositor. 2. Deposit of gold and currency with bank in trust for safekeeping were not general but special deposits. Traveler's check. Traveler's checks issued by plaintiff bank and delivered to defendant bank, which executed trust receipt promising to sell checks for not more than specified price and to hold proceeds in trust and to account for such proceeds and checks, including lost or stolen checks, were held to constitute special deposit under contract, creating bailor-bailee relationship. While it is certainly true that parties may by agreement give to deposits which would otherwise be general the special character of trust funds, an agreement definite by fixing the character of the deposit as general may not be disregarded, because if the depositor had fully known the law and the facts, the bailee would have acted differently for his protection. Relation of depositor to others. Deposit which it is agreed and understood that bank may use as general deposit is general, regardless of the relationship between the depositor and other parties. Passing of title and right to drawer, to drawee. To create a general deposit, the money must be with the depositor's knowledge, credited to deposit account, and with full right to draw against it for all purposes. There must be a passing of the title to the bank for that purpose, and where a deposit did not fulfill such requirements, it was not general. Right to use fund. If the contract between the parties takes away from the bank the right to use the fund deposited as it uses its general deposits, then it is a special deposit. If, however, it is agreed and understood, either expressly or impliedly, that the bank may use this deposit as it uses its general deposits, then, in the absence of any wrongful intent, the deposit is a general one, no matter what the relation between the depositor and other parties may be. Limit, control by third party. Limited control by third party. The fact that another party may have some control over the deposit so that he must countersign checks before money can be paid upon it does not alone make the deposit a special one. Right versus fact of commingling. Right of bank to commingle and use deposits is determinative of whether deposit is special deposit and not the fact of commingling. Agreement for commingling. Rule with regard to creation of special deposits has not been relaxed to the extent that where money deposited is to be used for a specifically designated purpose, it may still be regarded as a special deposit, even though the funds were deposited under an agreement allowing them to become commingled with other funds in the bank. And they are so mingled that identical money deposited can no longer be identified. Unauthorized mingling. Where a draft was delivered to a bank pinned to a contract for the sale of land with instructions to the bank to hold the draft until the completion of the contract, the act of the cashier in taking the draft from the contract of his own motion, making a deposit slip therefor, and mingling the proceeds of the draft with the general funds of the bank without the knowledge or consent of the depositor does not change the deposit from a special to a general one. Return of bonds of same issue. A delivery of bonds to a bank for safekeeping without a provision that the identical bonds were to be returned to the consumer, but only that bonds of the same issue should be returned, is not a special deposit, to constitute which it must appear from the agreement of the parties that a return in kind was contemplated. A bank deposit is special where the bank becomes bailee and title to the deposit remains in the depositor. It is general if title passes to the bank and the bank has the right to use the deposit in its business, being bound only to return an equal amount or any part thereof, usually on demand. To make a deposit special, the bank must be made an agent or trustee rather than a debtor. Earmarking. A depositor may establish an account in a bank under a special designation or earmark as a particular account, and yet, in the absence of an agreement with or instructions to the bank that the account is a special deposit or to be used for a special purpose, a specific purpose, the deposit is to be regarded as belonging to the general account of the depositor and may be so treated by the bank. See if I can read this one. I got all scrupled up. All right. Special names. The fact that plaintiff opened accounts under special names was not sufficient in and of itself to stamp them as special deposits. The court saying very frequently a point may open several accounts at the same bank, one for business purposes and yep, I'm not even going to try that because it's all scrupled up. Sorry, guys. That's why I marked it in blue. I'll have to dig out the book and go find it for you guys. I don't want to provide you information on a that's inaccurate. All right. Mere use of the word special placed after the depositor's name will not cause a deposit to come within that category. Agreement governs. It is not essential to designate an account as special in order to establish that it has such character, this question being determined by the agreement between the parties. Designation on deposit slips. The lack of any special characterization of an account on the deposit slip warrants a bank in treating the deposits as general only in the absence of information that they were in fact made for a special purpose. Right to draw for all purposes. Where the deposit is placed in the general checking account of the depositor with his knowledge and with the right in him to draw against it for all purposes, it is a general deposit, and title thereto passes to the bank. Factor for consideration. That money has been placed in general checking account is not conclusive that deposit is general, but is fact to be considered together with other facts and circumstances, including conduct of depositor and bank. Contract expressly to contrary. While the agreement to pay interest on a deposit may be a circumstance to be considered in determining the relation of the parties, this of itself is not sufficient to overcome express provisions in a contract. Designating a deposit as a special deposit to be held and used for a particular purpose. Later conduct of depositor. Generally, deposits, although special when made, may become general by later conduct of depositor, and mere fact that depositor has issued no checks to deplete his account before amount specified is not conclusive that special deposits may not for other reasons become general. The mutuality of agreement between the bank and its depositors, which is necessary to convert the relationship from that of a general depositor to that of a special depositor, is found in the nature of the depositor's agreement with the bank, which is consented to by the bank in its acceptance of deposits, namely, that depositor shall have the right at all times to withdraw their deposits and thereby terminate the relationship of creditor of the bank on demand. The demand having been made and acknowledged by the bank, the previous relation is in contemplation of law necessarily ended, giving rise to a succeeding relationship in which title to the deposit becomes vested in the depositor, the bank holding the fund as trustee. Charge not shown. Money deposited in checking account was general deposit, as distinguished from special deposit, and depositor was not entitled to preferred claim on bank's insolvency, notwithstanding depositor's requested bank to purchase bonds and authorized bank to draw check against account to pay for bonds or to charge account with amount of purchase price of bonds when they should be received, where bank closed before bonds came and before check was drawn against account or account was charged. Cashier's conclusion. If proceeds of bonds were accepted by bank, in trust for fixed purposes and depositors in good faith left designated proceeds in bank for purposes of mutual agreement, although proceeds were credited to depositor's checking account, cashier conclusion as to what he would have done if depositor had broken agreement and presented check for proceeds could not change deposit from special to general. A special deposit made by one already a depositor at the suggestion of an officer of the bank in order to keep the funds belonging to another party generate and apart from those of the depositor does not lose its character as a special deposit by an item belonging to the depositor in individually being deposited in that account. Converting proceeds of bonds. Where Liberty bonds are placed for a safekeeping in a safety deposit box in a state bank and without the owner's consent or authority, the officer of the bank abstract such bonds and sell and convert the proceeds, the relation of bank and general depositor is not created. Drawing against funds for where a special deposit was made for purposes of organizing a bank, that trustee thereof drew against funds for purposes other than organization did not change deposit's character as special, but was simply an unauthorized division thereof, drawing against fund for unauthorized purposes. Where a special deposit was made for purposes of organizing a bank, that trustee thereof drew against fund for purposes other than organization did not change deposit's character as special, but was simply an unauthorized diversion thereof.